Thank you for joining us in this webinar, Right to Work Check. We're in webinar mode, which means the webinar is being recorded. We are going to be posting it on our YouTube for people who are not able to join us, and if you need to watch it again. My name is Olaide Osazua, and I am presenting this webinar on behalf of Legal Immigration Lawyers. Thanks again for joining us. We are going to begin the webinar with a video, just a welcoming video to let you know what we are going to be discussing this afternoon. So we'll get the video to start the webinar. Please give us a few seconds while that video is loading.
Why you're here today matters. Every day across the UK, businesses are building something, not just products or services. They're building teams, careers, livelihoods, and sometimes without realizing it, they're building risk. Right to work check sounds simple. A quick ID check, a passport scan, box ticked, move on. But here's what most employers don't realize. One missed step can cost you £60,000 per employee. One incorrectly stored document can trigger a Home Office audit. One good faith mistake can turn your hiring decision into a legal nightmare. And it happens to good employers every single day. You know compliance matters. You're not trying to cut corners. But the guidance, it's hundreds of pages. The rules, they keep changing. The stakes, they're higher. And somewhere between running your business and trying to decode Home Office regulations, the risk just grows. That's the gap we're here to close today. In the next hour, we're not going to overwhelm you with legal jargon. We're not going to scare you with worst-case scenarios. We're going to give you clarity, clear steps, practical tools, honest answers, so you can hire with confidence, protect your business, and sleep better tonight. Thank you for being here. Your time matters. Let's make sure it's worth it. Welcome to Right to Work Checks, Legal Duties and Risks for Employers. Let's get started.
Thank you. Thank you very much. I hope you enjoyed that video. So we are not going to waste time, any time for that. We will start straight away. So in this webinar, you're going to learn how to do right to work check and the consequences if it's not done properly. Why right to work checks matter. Every employer must make sure every person they are employing is allowed to work in the UK. Now, what do you have to do as an employer? Before the person starts their job, check their right to work, check their papers, check their visa to see if they are able to work lawfully. If that is not done, it's a big risk for your business. Now, you only have to do right to work check if you are employing someone as an employee. This is any contracts you have with an employee. It could be written contracts, it could be oral contract. As long as they are defined as an employee by HMR rule, then you have to do right to work check for them. If they're self-employed, you don't have to do right to work check because you are not employing them. So if you are employing someone as a consultant, if they are self-employed, you don't have to do right to work check, but you have to do it for self-employed if you are sponsoring the worker, and you have to keep record. Now, who is responsible? Because a lot of organizations, they delegate this task. Some could have their employees doing it for them, another employee is doing it for them. Some may have instructed a third party, like a lawyer or a recruitment agency. Who is responsible if the right to work check is not done correctly? The simple answer is it is you as the employer that is responsible if the right to work check is done correctly. So that's why it's important that staff are trained and you as the employer make sure the right to work check is done correctly. Of course, when we say employer, it depends on how your business is operating. If you're operating as a sole trader, that means you as an individual is responsible. If it's a company, the company is responsible. Now, how do we do the right to work check? How is it done? So generally, there are three ways that it can be done. The first one is the manual check. The second one, which only applies to British citizens and Irish citizens only with valid passports, is the right to work check using a digital verification service. And the last one is the Home Office online right to work check. There is also another way that is being done, which is the employer checking service. We are going to talk about all of these methods as we progress in this webinar. Now, there are some things you have to do as an employer when the right to work check is being done. One of the first things you have to do is to keep records. You could have done the right to work check, but if you don't keep the records, it's as if it was never done. So records must be kept throughout the entire time the person is working with you and 2 years after they've left the employment. That is what the Home Office wants you to do as an employer. Keep it for the entire period the person works with you and 2 years after they ended the employment. So that's the first thing you have to make sure you do when you conduct right to work check, record keeping. Now, there are generally three methods, three processes you have to go through depending on the method you are using. But generally, three processes you have to go through. If you're doing the manual check, the digital verification, or the online employment check, you have to go through this process generally. The first one is obtain the documents. Once you've obtained the documents, then check that the documents are correct and, of course, keep the record. Now, depending on the right to work check you are doing or the immigration status of the employee or the prospective employee, your right to work check we usually produce two results generally. One is a continuous excuse and one is time-limited excuse. I will explain both. For continuous excuse, it means once you've done the right to work check and you've done it correctly, you don't have to do it again throughout the period that the person is employed with you. So that's why it's continuous excuse. But the time-limited one, we usually give you a certain time, usually when the employee visa is due to expire, and say you have to repeat this right to work check on or before that date. Yeah. Now, there is a time when you can have an excuse if you do it after that date. So if you carry out a right to work check, be it a manual right to work check or online right to work check, before employing someone, and the person visa then expire or the right to work check then expire, you could have 28 days of protection. Yeah, 28 days of protection if you reasonably believe the worker has an outstanding application with the Home Office, that is, they've made an application to extend their visa, or they've appealed the decision of their visa and is still pending, and they can produce documents to, usually before you have that reasonable expectation, it's good practice to obtain evidence of this from the employee. So if your employee has a pending application or a pending appeal or a pending administrative review, and the time-limited right to work check has expired, you are protected for 20 days if you have reasonable belief that they've made an application to the Home Office. But within the 28 days, of course, you must take action. You must either do a right to work check or contact the Home Office to get a positive verification notice through the employment checking service. Just to note, if you have any question, you can put them in the Q&A. I will be picking them up, or at the end of the webinar, you can ask any question you have. But please feel free to type your question in the Q&A. Now, let's go into the methods that you can use to do right to work check. The first one is the manual one. Now, for the manual one, you can use it for any employee, regardless of their immigration status. And this involves collecting, the first step is collect the documents. You must see the original documents. Now, the Home Office has created two lists, and they've categorized it as List A and List B. For List A documents, if you are able to obtain original copies, of course, you must see the original. That's the first way, collect the document. If you are able to collect a document from List A, then you will have continuous statutory excuse, which means once you've done it correctly, when I mean the right to work check, once the right to work check has been done correctly, you don't have to repeat it for that employee. So things you will find in list A, examples of documents you will see in list A are things like British passport, Irish passport, passport from any other country that shows that the person has indefinite leave to remain or settlement visa, plus an official national insurance number. When I say official national insurance number, I meant it must be from official document. Maybe a letter from HMRC, their payslip. It won't be sufficient if the employee just write their national insurance number for you on a piece of paper. No, you have to see it from official source. So if an employee gives you their British passport, for instance, that's the first step in the manual right to work check. If they're giving you an Irish passport, that's the first step in the manual right to work check. If you have someone who is not a British citizen or an Irish citizen, regardless of the country they've come from, they're giving you their passport. And inside that passport, you could see a visa that shows they have settlement or indefinite leave to remain in the UK. And they are also giving you their national insurance number, for instance, from HMRC, a letter from HMRC or DWP confirming their national insurance number. That is also sufficient evidence. But yeah, generally for list A, there are documents that give you continuous statutory excuse. List B are documents that are time limited. Usually, once you collect these documents, you have to repeat the right to work check at a certain period, depending on the time stipulated in the document. The usual example that we get in this at the moment is visa. So there are still some few categories where the Home Office will issue the visa on a physical passport. Now, that is gradually fading with the introduction of e-passports. But if a client gives you an immigration status document that allows them to work, then and the visa is still valid, you could accept it under the manual right to work check on list B. You need to look at the list and then make sure it falls into that category. So the first thing is obtaining the documents, original documents. The second is check the documents. So when you receive the document, you must look at them carefully. Make sure it belongs to the employee and they are allowed the right to work. Yeah, so things like checking the photo, is it the employee that wants to work with me? The date of birth, does it match the other documents they've presented to me? The visa, is it still in time or has it expired? Does the visa allow them to work or does it not allow them to work? Because a lot of visa now, we usually have a comment telling you whether the person is allowed to work or not. Does it look genuine? Does it look genuine? Has it been tampered with? Does it belong to the individual? If there is anything you are not sure of, seek clarification. For instance, if they've changed their name, ask them for the change of name deed or the marriage certificates or some evidence to confirm any discrepancies that you might have noted for the document checking. Now, the last thing, so check the document, obtain the document, check the documents. Now, one point I would emphasize again is that you can check the person by video call. You can do it by video call. They're standing in front of you. You can do that. But when you are doing it by video call, you still have to make sure that you have the original document with you. So it could be that they posted their passport to you, and you are now verifying by video call to make sure the person on the passport is the same person you want to employ. Yeah. And of course, once you've checked the person, then you have to keep records. Don't forget, you must keep records throughout the period that the person is employed with you and 2 years after the employment is terminated or the employment ended. Now, make a clear copy of any document. Now, this is another important point. I've been to audit where they've done all this, but they haven't noted the date that it is done. So it is very important when you are copying the document that you keep a record of when the right to work check is done. A lot of times, a lot of employers I've seen, we usually make a note, write original of this document sent by me on so date, or right to work check done on so date by me, and they'll put their name there. If that is not done, the Home Office don't know when you've done the right to work check. So it's very important to date it and to confirm when the right to work check was done. You could either write it on the document or you could keep a separate record. It's up to you how you want to do it. Whatever works for your team or for your business. Just make sure it's dated, because don't forget, right to work check has to be done before the employment starts. And if you don't have a date, or if you don't keep a date of when it was done, there is no way for the Home Office to know when you did it, whether before employment or during employment. Now, what documents do you have to keep? Passports, you have to keep the passport of the employee, usually the biodata page. But what the Home Office has said is you keep the passport and you keep the pages showing the expiry date of the passport, the nationality of the employee, their date of birth, their signature, and the visa, and the page that has their biometric details, as well as their photo. Most of the time, it will be the biodata page of the passport that has all this information. And any other page in the passport that shows the person's visa or their right to work check. You do not need to copy the front cover of the passport anymore. And of course, if there is any other documents that you are relying on in the process of the right to work check, you must keep the old documents, back and front. Again, please feel free to put your question on the Q&A and we will pick them or we'll answer them as we progress. So that is the manual right to work check. The next one is the digital verification service. Now, the manual check is available to everyone. When I say is available to everyone, is you can use it for any employee. However, the digital verification one can only be used for British citizen and Irish citizen who has a valid passport or a valid Irish card. So if the employee is a British citizen and their passport has expired, you cannot use the digital verification service for them. You have to use the manual check or the other method we will talk about shortly. The digital verification service, again, is available only for British and Irish passports that has a valid passport or a valid Irish. Again, once you've done the DVS, the digital verification service, it gives you a statutory excuse, a continuous statutory excuse. Now, a lot of people do get third parties. I mean, that's the whole essence of the digital verification service, to do this. When you are getting a third party or the digital verification service provider, you must make sure they follow the rules recommended by the Home Office, and you should get evidence from them on how they've done the check, and that's you reasonably believe that they have done the check in accordance with the Home Office guidance. And for you to have a measure of protection or to have a bit of assurance that they are complying with the Home Office guidance, it is safer to use certified DVS provider. The government has a list of certified DVS provider, and by them being certified, it shows they are complying with the government standard. It's not compulsory for you to use a certified DVS, but it's highly recommended because of the trademark of meeting the standard stipulated by the Home Office. When they've done the check, you should get a copy of the check that contains all this information. Of course, the name of the individual, their date of birth, image of the passports or passport cards they've used, the photograph of the person, date that they've done the check, and the name of the DVS. You have to, they've done the right to work check, that's collecting the information. You then have to check that the information is correct as the employer. Again, similar to manual right to work check, you have to make sure that the details match the person that wants to work for you or that is applying for the job. Make sure the person is not an imposter, so the person standing in front of you or that you are doing a video conference looks like the result of the DVS that has been provided to you. Most DVS providers, they usually grade the identity check. They usually grade it by low, medium, high, and very high. So ask them for the level of confidence. Now, make sure the DVS check was done properly and make sure the passport is still valid at the time that the check was done. Remember that the DBS can only be used for British citizen who has a valid passport, or Irish citizen who has a valid passport or a valid Irish card. If the passport has expired, so when you get the result back from the DBS provider, and on this page you notice the passport has expired, then it will not be a correct right to work check as of today. And if there is any other information you need to clarify, like the name, like we said, get their marriage certificate, get their change of name deed, and retain copies on your record. Copies must be kept for the duration of the employment and 2 years after the employment has ended. So that is the digital verification service. The third way to do right to work check is the online right to work check. This is the most common one for people who are not British citizens or Irish citizens. So the Home Office for some time now has been introducing e-visa. So with anyone that has an e-visa, you can do the online right to work check for them. The way it's done is the employee logs into their UKVI account. So for them to get an e-visa, they will have a UKVI account. So they log into the UKVI account, they generate a share code, and they can either give you that share code, give it to you manually, face-to-face, email it to you, or they can ask the system to email it to you. Once you have the share code, then you will go to the Home Office website. The Home Office page looks like this, and then enter the share code as well as their date of birth to check whether the person has the right to work. Few things to note: the share code is usually valid for 90 days, and you can use it as many times as you want or as necessary. Not that you have to repeat the right to work check once it's done, but if for any reason you want to repeat it, the share code is usually valid for 90 days. And of course, so once they've given you the share code, you've done the right to work check. Again, make sure the information matches. So their name, make sure they're not imposters. It looks like the person standing in front of you. If we are doing the check on video, make sure the information tallies. And if there's anything that is not consistent, typical example that I've given is name. If they change their name or they have a marriage certificate, obtain a copy and keep it in the system. Now, the online right to work check is usually time limited, because it might not be time limited. Sometimes you get people on indefinite leave as well on e-visa. So the e-visa will tell you whether it's time limited or not. Now, there are about 3 share codes, and they are used for different things. So when your employee is giving you the share code, make sure it starts with the letter W. If it doesn't start with the letter W, then it's not a right to work share code. And if you use any other type of share code, it won't be sufficient for your right to work check. Okay? So we move on to the employer checking service. Now, this can be used if you are not able to do manual check, or the employee is not a British citizen, so you can't do the identity verification, or for whatever reason, maybe the employee tells you that, oh, I'm trying to generate my share code, but it's just not working. So the employment checking service is more or less a way of contacting the Home Office. You give the Home Office the person's detail, and they will check for you and confirm whether the person has a right to work or not. You will usually get a response back from the Home Office within 5 working days, and you should tell the employee that you are requesting right to work check for them using the employer checking service. Because part of the question when you are doing it is, do you have their consent to do this? Now, sometimes we have a situation where the employee has a pending application with the Home Office, and the e-visa or the online right to work check is not working. If that is the case, the Home Office recommendation is to wait for about 2 weeks, 14 days after they've submitted the application, just for them to update their record before asking for the employment checking service. However, even though they said 14 days, in practice, I think they seems to be getting better in updating it when someone submits application. I've had few people that almost immediately or by the next day that they've submitted their application is already reflected on their records. But if it's not reflected, if your employee has submitted an application, is pending with the Home Office, and they've tried their share code, it's not showing that they've submitted an application or they have the right to work, then you can use the employment checking service. If you have a positive verification from the employment checking service, it is usually valid for 6 months. So it's a time-limited excuse. We generally have to repeat the employment checking service every 6 months or however long is stipulated on the document. Now, we are going to talk about some specific routes, specific categories. The first one is the Windrush generation. Obviously, the Windrush generation came to the UK a long time ago, before 1973. So if you have a client that arrived in the UK before 1973 or between 1973 and 1988, most of them don't have documentation to prove their right to work. And you may need to contact the Home Office to verify their right to work check. The Home Office has a dedicated team for the Windrush team, but if you have a client like that, then do the employer checking service. We also have the EEA citizen. Now, due to Brexit, of course, the UK left the EU, the European Union community. So if you have an EU employee that is about to start work for you, since July 2021, their passport alone will no longer be sufficient. You have to do either the manual right to work check or the online right to work check. However, if you've done the right to work check before 1st of July 2021, imagine someone that's been working for you before 1st of July 2021, you don't have to repeat it if you're EU citizen. Retrospective check are not necessary. But if you are employing someone new, or maybe you are just doing making sure your compliance is right, you also have to be careful of discrimination rules. You can't do right to work check for all your employees, for instance, and exclude one. So if you have updating your right to work check, then you might have to do it for all your EU citizens as well, even though you could have done it before July 2021. And in that case, you have to do it either using the online right to work check or the manual right to work check. The passport for EU citizen is no longer enough evidence to show their right to work check. Then we have frontier workers. Now, these are EU citizens that live outside the UK, but they come to the UK to work, be it self-employment work or employed work. They could be self-employed or employed work. They also have the right to work under the EU withdrawal agreement. But they are normally issued a digital work permit document. If they're issued that and they give you that, that is fine. But if they've not given you that, then again, you have to do the employer checking service. In addition to doing the employment checking service, you also have to collect some information from them. And these information are proof of their identity, usually their passports. We will normally get that. Most employers will normally get that anyway. Prove that they mainly live outside the UK. Remember, they live outside the UK, but they have the right to come into the UK and work. Prove that they were working in the UK on or before 31st of December 2020. For instance, pay slips or invoices or contracts, and prove that they have continued working in the UK after this date. Yeah, so you do if they've not given you their digital frontier work permit, you have done the employer checking service, you also have to keep this on records for them if you're employing a frontier worker. Then the other one I've talked about is the sponsored worker route. Now, in order to employ someone who is not settled in the UK or who is not a British or Irish citizen or otherwise doesn't have the right to work, generally people from overseas that you want to recruit, you generally would need to get a sponsor license. So once you have a sponsor license, then you can sponsor someone to work for you. They will be granted visa to work only for you because you are the one sponsoring them. And of course, as part of the process of getting the sponsor license, you would be required to know how to do right to work check. However, sponsored workers can do supplementary work, extra work. They are not restricted to working only for their sponsors. But when they are working for someone else that is not their sponsor, they must meet certain conditions. One part of the condition they must meet is that they must ensure that they are working for their current sponsor, because it's supplementary work, it's second job. It's not a case of doing mainly the supplementary work. So they must ensure they are working for their main sponsor and meet certain rules about supplementary work. And the supplementary work must not be more than 20 hours per week, and it must not take place during the hours the person is contracted to work for their main sponsor. And you, as the employer, must also make sure they are not working for you when they should be working for their employer. So usually you would normally have them or ask the sponsor to give you a letter to confirm their working hours. And you have to put down their records to make sure you don't give them work at the time when they should be working for their main sponsor or for their sponsor. We also have students who are in the UK. Not all students, not all international students are allowed to work in the UK. If they are allowed to work in the UK, their passport, their visa, be it their e-visa or their paper visa, will normally show it whether they are allowed to work. But generally, if they are allowed to work, they will be permitted to work 20 hours during term time. So when the school is in session, 20 hours or 10 hours during term time. And when the school is not in session, they are allowed to work full-time. So students are allowed to work full-time before their course starts, during holiday or vacation, or after the course ends. Now, a week runs from Monday to Sunday. So if you're going to employ a student, make sure they are not working for you for more than 10 or 20 hours during time times. And students can generally not take a full-time job unless they have applied to switch to skilled worker visas, or they've completed their course, or they have permission in doctorate extension scheme. Generally, students cannot work as an entertainer or professional sport persons. Now, that is generally the way right to work checks are done. We've talked about the manual check, the digital verification service, and the online right to work check, including the employment checking service. So what happens, or what could happen if the right to work check is not done? Now, don't take it lightly, because there are big penalties. Before we do that, we'll just play a second video, and then we'll go into the risk or the penalties if the right to work check are not done correctly. So can we have the second video, please?
This is why it matters. Let me tell you about Aisha. She came to the UK from the Philippines 5 years ago. Trained as a nurse. Dedicated. Loved by the residents she cared for. She worked night shifts at a care home in Leeds. She sent money home to her children every month. She was building a life here. Until the day the Home Office came. The care home manager had done a right to work check. He'd seen Aisha's passport. He'd made a copy. But she hadn't checked the visa expiry date. Aisha's visa had expired 3 months earlier. She didn't know. Her employer didn't know. But the Home Office did. The care home was fined £45,000. Aisha was told she had to leave the UK immediately. The residents, they lost someone who knew their routines, their preferences, their stories. The care home, they lost £5,000 they didn't have. And they lost a staff member they desperately needed. And Aisha, she lost everything she'd built. Her job, her home, her future here. This wasn't about bad intentions. This was about one unchecked detail. Right to work checks aren't just about avoiding fines. They're about protecting people, your employees, your business, the lives you're building together. That's why getting this right matters. Not because the law says so, because people's futures depend on it. So let's make sure you know exactly how to protect everyone involved. Here's what you need to do.
Thank you. Yeah, hopefully from that video, you've seen the importance of doing the right to work check. But just to emphasize them again, think the first thing in the case of Aisha was a fine. So there could be a civil penalty if the right to work check is not done correctly by the Home Office. They could issue the business a civil penalty, and it could be up to £60,000 for each illegal worker. Yeah. Other consequences could be criminal offense, up to 5 years in prison, and unlimited fine. The business can be closed. The court can give a compliance order, and license could be revoked as well. For instance, if your business involves working with in the food section or the alcohol section and you require a license, that license could be revoked. The government could ask you to pay back the earnings you've made through the illegal working. And of course, the reputational damage for the business. The business could have its name published as a business that hired illegal workers. Think other things as well to look out for, things like your insurance. It could mean that your insurance is invalidated because you've not confirmed the identity of the person working with you. So we mentioned in the video as well, it does affect the employee working for you. So protect your business, ensure your right to work checks are fully compliant. Before we go into like I said, you can pull the questions in the Q&A. We'll just have a final video and I'll come back to answer the questions as well.
What happens next? In the last hour or so, you've learned how to conduct compliant right-to-work checks, what documents to accept, how to store them, what mistakes to avoid. You've seen the risks, you've seen the costs, you've seen what happens when it goes wrong. So now what? Here's where you have a choice. You can walk away from this webinar, hope you remember everything, and try to implement it on your own. Some of you will get it right, some of you won't, and you won't know which one you are until the Home Office shows up. Or you can make sure you get it right the first time. You can protect your business, your staff, your future, not by guessing, but by knowing. That's why we're offering the first 10 people or organisations who registered for this webinar a free 15-minute consultation. Not a sales pitch, just a conversation. We'll review your current right-to-work process, spot any gaps, and tell you honestly what you need to fix. If you're already compliant, we'll tell you. If you're not, we'll show you exactly what to do. No obligation, no pressure, just clarity. Because compliance isn't just about avoiding penalties. It's about building something that lasts. Teams that are protected, businesses that are secure, lives that aren't disrupted by mistakes you didn't know you were making. You showed up today. You invested your time. You're taking this seriously. Now let's make sure it actually protects you. Check your email for your free consultation link if you were one of the first 10 to register. And for everyone else, we're here when you need us. Thank you for being here. Now, let's open it up for questions.
Thank you.